Welcome to the Marijuana Industry Victims Seeking Justice webinar, where we will discuss pathways to bring accountability to the marijuana industry. Every Brain Matters is proud to have this historic webinar. We are a community that was developed by families affected by marijuana in order to support and advocate for other families and communities affected too. We want to thank our grantors and our supporters like Smart Approaches to Marijuana, the Parent Action Network, Parents Opposed to Pot, Americans Against Legalization of Marijuana, Mom Strong, DUID Victim Voices, and Jennifer's Messengers. We also want to thank each and every one of you who has volunteered for us and has given us donations. And we acknowledge the families who are working hard to seek and file lawsuits. We thank you for standing up for all of our families. The expansion of marijuana and other drugs has overwhelmed our country and has become a regular part of our culture. This new age of industrialized THC allows predatory practices from an industry that is profiting off addiction and mental illness, and has well-funded campaigns to target vulnerable populations with minimal accountability. And as a result, our neighborhoods and our schools are becoming unsafe. Families are undereducated and have minimal tools and resources to prevent, manage, and recover from the impacts of marijuana addiction, psychosis, toxicity, impairments, and other mental challenges that come from these products. Our legislators are consistently hearing from drug advocates and lobbyists, and they do not hear enough from us. If you want to change this, we invite you to join us. We need your voice. We need your support. Please click the link in the chat, sign up for our newsletter, and get involved with our efforts, and consider giving us a monthly donation. We need your financial support. I am honored to introduce Dave Evans, a plaintiff litigator and senior counsel for an advocacy group called Cannabis Industry Victims Educating Litigators. Dave is a compassionate and effective advocate who has prepared legal guides to sue the marijuana industry. He frequently appears on major news outlets such as CBS, CNN, Fox News, and NPR. Then we will hear from George Hritz, who is a graduate of Princeton University and Columbia Law School. He represents corporations and individuals. He is a thoughtful, compassionate, and skilled courtroom veteran. He has worked for some of the top law firms in the country and has recently filed a marijuana industry lawsuit in New York. Then we will meet Aaron Kress, a graduate of the University of New Mexico School of Law. His practice focuses on defamation of claims, contract disputes, internet issues such as doxing, cyberbullying, and content takedown, and account restoration. He is currently working on 2 significant marijuana industry class action suits and is seeking plaintiffs for these lawsuits. So please stay tuned to learn more about this necessary and historic step. Dave Evans, George Hritz, Aaron Kress, we welcome you and we thank you for being here. And we turn the floor over to you, Dave. You can go ahead.
Hi, everybody. I'm David Evans, and I'm going to talk for about 20-25 minutes, just giving you the basics on the causes of actions that could be taken against the marijuana industry. George Hritz is then going to talk about evidence and what you should be gathering to prepare you for a lawsuit. And then Aaron is going to talk about class action lawsuits, which is something that are long overdue against the marijuana industry. The PowerPoint and any other documents are going to be sent to you after the session, and we encourage you to distribute them. and to talk to lawyers about this. We want to get lawyers on board. Now, the biggest problem that we have in litigation against the marijuana industry is the false perception that marijuana is harmless. I have been stunned when I have debated marijuana lawyers, that in other words, lawyers that are pro-marijuana, on their ignorance about how damaging marijuana is. This perception limits us in legislation, limits us in getting the government to do something about it. I have pretty much lost faith in the government to do anything about this problem. And as was done with tobacco and as was done with the opiates, we need to resort to the courts. The marijuana industry has overwhelming resources compared to our resources in terms of lobbying and public advocacy. But one place where we can go toe to toe, where there is equality, is in the courts. And those decisions will be made by evidence and not just lobbyist talking points. Now, there's a lot of causes of action that could be brought against the marijuana industry. You have to think of them as the same as the opiate industry, the tobacco industry, the food industry, the alcohol industry, all of those causes of action, and the medicine, pharmaceutical industry, all those causes of action can be applied to marijuana. Consumer product liability, false advertising. There's a lot of false advertising about marijuana products, that they have medical cures, CBD in particular. There are all kinds of false claims being made about CBD. CBD is dangerous, and I'll talk about that a little bit later. Causes of action. Medical malpractice. Marijuana is being used in the majority of the states for medicine. It is not proven to be a medicine. It's causing a lot of damage to people, killing people. I personally believe that it is malpractice for any doctor to recommend it. Workers in the marijuana industry also are exposed to pesticides, heavy metals, fungus, and other forms of contamination, as are the customers of the marijuana trafficking operations. I don't call them dispensaries. They're marijuana trafficking operations. We've had numerous incidents of marijuana being contaminated with heavy metals, fungus, other forms of contamination. The states are doing a very poor job of keeping marijuana clean. There's also RICO, which is the Federal Racketeer Influenced Corrupt Organization Act. If you are damaged in your property, say you have a marijuana growing operation next door to your farm, and it's bringing down the value of your farm, you can sue. Next slide. Other causes of action are server liability, just like alcohol liability, that somebody, a bartender serves somebody too much alcohol and they go and get in a car crash, you can sue the bartender. There are a lot of damages being caused to children. As many as 30% of the pregnant women in California have been using marijuana. It's outrageous that is happening. Even though California has very strong warnings against that, in Colorado, an undercover investigation was done. A woman called around to the marijuana stores and said she was in her first trimester of pregnancy. Would they recommend marijuana? 66% of them recommended marijuana. Marijuana causes birth defects and a lot of other problems, developmental delays, underweight births. Also, the number one cause, the number one drug-related cause of deaths for children caused by parents or caretakers is marijuana. We have data for that in a couple of states. There's also a lot of environmental pollution going on because of marijuana. And then some states have drug dealer liability acts, states that have not legalized marijuana. And in Drug Dealer Liability Act, you don't even have to know who gave your child the marijuana. Anybody selling marijuana in your state could be sued under Drug Dealer Liability Acts. So that is something you need to be aware of. Next slide. I'm not going to go into a lot of details here because there's a lot of information here, but the point is that marijuana cannabinoids interact with a lot of prescription medications, and nobody is telling people that. And in some cases, it interacts with sedatives, bronchodilators, Prozac, antidepressants, and blood thinners. So people could be using marijuana and it can cause them to bleed. They're now starting to recognize that anybody about to undergo surgery should stop using marijuana. Next slide. CBD and marijuana also interact with all of these medications in a negative way. And nobody is warning people about this. And a lot of people are using it thinking that marijuana is helpful. It's healthy. It's a medicine, and it's actually causing them to have negative reactions with their medications. CBD. The public perception of CBD is that it's a wonder drug. It doesn't have THC in it. Supposedly, although studies done by the FDA show that a lot of CBD products do have THC, but they're pushing CBD, particularly with older folks. CBD has not been tested by the FDA for anybody over the age of 55. It can cause mental illness, suicidal ideation, and liver damage. Anybody using CBD should have their liver enzymes monitored, particularly older people who have liver problems. They're not being told that, and they should be. Today's marijuana products, next slide, have very high THC levels. Some marijuana products, next slide, can be 94%. You see here 95% THC. The problem with edibles is that people eat them, they don't get high right away because it takes longer to get into their system. But this is being advertised as medical marijuana. These are examples of medical marijuana, 94% THC. And there is no evidence really, peer-reviewed, FDA-approved evidence that marijuana is helpful for any condition. Some cannabinoids could be helpful. Properly manufactured one product has met FDA clearance, but no smoked marijuana, no edible marijuana has met FDA clearance. There's 2 THC drugs that are made from synthetic THC that we know how they work. We know the warnings, and even those products say don't use if you've got mental problems. Next slide. Now, who are the victims of the marijuana industry? Children, birth defects, low birth weights, behavioral problems, accident victims. We have a woman whose daughter was killed by somebody high on medical marijuana in a car accident. Marijuana is definitely linked to violence, particularly domestic violence. Employers sustain damage from employees that are high on marijuana. There's environmental damage. Marijuana consumers are damaged by pesticides, heavy metals. These are toxic substances that are found in marijuana, including CBD. There's a lawsuit about that right now. The big one is people who suffer mental illness or commit suicide. We have case after case of people that have become mentally ill, psychotic, or suicidally depressed and have committed suicide. We have a personal injury case going in Michigan right now. There's also people who suffer physical disease. For example, many of the states that have legalized medical marijuana allow it for glaucoma, but that can actually cause people to become blind. The original study on glaucoma was years ago, and it showed that it lowered intraocular pressure in the eye, but they didn't do much more on that. And it turns out if you lower the pressure and then it goes back up again and lower it again, every time you smoke a joint, it actually damages your optic nerve. But this is an example of where this is, in my opinion, criminal to allow people with glaucoma to use this. But yet nobody is being warned about it, and nobody is being told not to do it. Property owners, next slide. Marijuana is addictive. There's no question about that anymore. 30% of those who use marijuana may develop some degree of marijuana use disorder. The Diagnostic and Statistical Manual 5 of the American Psychiatric Association recognizes cannabis abuse and dependence as cannabis use disorder. So if your child has become addicted, I think you can go to court and sue somebody for addicting your child if they did not give proper warnings. But I think even if they gave proper warnings, the substance is so inherently dangerous that, first of all, I don't think it should be sold at all. In New Jersey, they were going to put out a regulation that you could not, that you had to warn people that any THC over 40% could cause psychosis. So all I had to do was just warn people about this. So I wrote them a letter and I said, why are you allowing any product to be used that causes psychosis? Give me an example of any other product that can be sold retail that you know causes psychosis. But this is typical of this protective cover that marijuana has that we're trying to pierce now with litigation. Next slide. There's also cannabinoid hyperemesis syndrome. This is a condition where chronic use of marijuana causes bouts of severe nausea, vomiting, dehydration. This can kill you. People are showing up in the emergency rooms with this in the states that have had marijuana for a long time. Marijuana is also linked to brain damage, cancer, cardiac problems, and many other diseases. Next slide. Now, the laws that apply to the marijuana industry are the laws that apply to anybody who illegally, negligently, fraudulently produces a market or distributes any product. All marijuana distribution in the United States right now is illegal under federal law. Marijuana is used in foods and medicine. So any of the personal injury laws that apply to foods, medicine, intoxicants, that apply to opiates and prescription drugs can be used against the marijuana industry. Next slide. Federal law. The two laws here are the Federal Food and Drug and Cosmetic Act. Any use of marijuana or THC or CBD in food or as a food supplement is illegal under the Federal Food, Drug, and Cosmetic Act. Any using of marijuana, smoked or edible marijuana, is illegal to be used as a medicine. This has been decided by the United States Supreme Court. Marijuana is a Schedule I drug under federal law. It means it has high potential for abuse, for which there's no legitimate medical purpose in treatment. And there's a lack of accepted safety for use of the drug or other substances under medical supervision. This law has not changed since the Clinton administration, and every administration, Clinton, Bush, Obama, and Trump, have failed to enforce the federal food and drug laws. It's a disgrace. And we think that that this should be taken into federal court, and we're about to in New York. Next slide. A medical care provider may be liable to a patient or a third party for any adverse consequences of violating a standard of care. It is my opinion that a physician who assists anybody to obtain marijuana is in violation of federal law. It should be facing a malpractice claim. And the national standard for medicine approval is determined by the FDA, not by a state legislature. I mean, next slide. I often ask people, if you were going to get a medicine for your child, would you want one approved by the FDA or would you want one approved by your state legislature? And everybody laughs. Of course, they would pick the FDA approval. FDA approval means that the drug's chemistry must be known and reproducible. There must be adequate safety studies, well-controlled studies proving that it's not only safe but effective. According to the FDA and the DEA, marijuana does not meet these criteria. This has been litigated in federal court. It applies to CBD. One CBD medicine has been approved by the FDA by a reputable company, and it's only to be used for 2 rare seizure disorders in children, because it did have some effect on that, but it has no THC, and it's met the FDA approval. Nothing else has met FDA approval except that one product. Next thing. Next slide. A malpractice case could be tried either in state court or federal court if there is a federal question. So if to get the federal court to have jurisdiction, it has to be a federal issue. A state medical malpractice claim could be litigated in federal court because a violation of federal law regarding use of marijuana may present a federal question. That's been litigated in the Eastern District of Pennsylvania. We're using that in the federal lawsuit we're about to file in New York. So you can go into either court, and again, you have to get proper legal advice. Next slide. False claims. This is a big problem with marijuana, is false claims. They have been allowed to get away with grossly irresponsible claims about marijuana. You've all seen them on the internet, claiming that it cures or helps a variety of diseases. If you want to see how the FDA has responded to that, you'll see a site down there. It says Food and Drug Administration warning letters. You go on the FDA website and look at that, and look at some of the warning letters. There are dozens and dozens and dozens of false claims about medical marijuana, CBD, that the FDA has called out and said they're false. Next slide. Class action lawsuits. Aaron is going to talk about that. There have been several of them right now on such claims, only so far dealing with CBD. Hopefully, Aaron will, Aaron, by the way, seems very well informed and is not only there intellectually, but I think he's also believes in the cause. It should be taken against other marijuana products. Negligence. Negligence is the next slide. Negligence is a deviation from the standard of care in producing or selling or recommend marijuana. The standard should be the highest care. In other words, that you have to exercise the highest care in selling marijuana because the product's going into the human body. Negligence with marijuana could be failure to test the marijuana for contaminants, failure to inspect the marijuana, inadequate directions for use. That's a big problem. Failure to warn, huge problem. Design fault and statutory liability and contamination. The states are grossly negligent in failing to warn about marijuana use. Some states have done a good job when it comes to pregnancy. California has a good warning. New Jersey has a great warning, but it's not going on to the products, okay? New York State actually allows marijuana to be used for pregnant women without requiring that they be warned about the damage to pregnancy. That's medical marijuana in New York. Recreational marijuana carries the warning about pregnancy. Medical marijuana does not. This is part of our current lawsuit against New York. Next slide. Breach of warranty, that you sue somebody because you purchased marijuana and the product was not what it was represented to be. For example, if you buy CBD and there's THC in it or contaminants, that's a breach of warranty claim. Next slide. Product liability, another big area for lawsuits. Products are defective, there's negligence, failure to warn, particularly failure to warn about marijuana use and mental illness. There is what's called the learned intermediary doctrine, where if you're using medical marijuana, the liability then gets passed on to the doctor. So if you're going to be suing a marijuana trafficking operation in medical marijuana, please bring that doctor in. Product liability, anything labeling marijuana as a medicine, it comes up with product liability problems, false claims, over promotion of the product, engaging in civil conspiracy, causing a wrongful death. We have a case right now in Michigan where a young man had Crohn's disease, was recommended to use medical marijuana. He became suicidally depressed as a result and killed himself. Next slide. Strict liability is a legal term which means that you have strict liability for what you do, that your ability to defend yourself is limited. And this may apply to marijuana products that are contaminated, defective, fail to meet standards. Under federal law, marijuana is not considered to be safe and effective as a medicine. and to use it without FDA approval may impose strict liability. Next slide. Now, there's also claims that can be based on state consumer laws. For example, in Ohio, they use the following state consumer laws against opiate manufacturers: public nuisance, sales practices, Medicaid fraud. If anybody's getting medical marijuana and Medicaid or Medicare is paying for the doctor, that's illegal in our opinion. Corrupt practices. So there's going to be a number of state law claims that can be added on to any federal claims. Next slide. Informed consent. This is another big area where the marijuana industry is getting away with murder. Providers have to explain what is going to happen when they use this product. The main problem is doctors just don't know. They may be required by the state to take a 2-hour or 10-hour course, but that is nowhere near adequate to explain all the different problems that marijuana causes. Next slide. Failure to warn, again, another big issue. There are so many risks with marijuana use. Now, we, Americans Against Legalizing Marijuana, has put out a booklet on the risks of marijuana use that go into every problem, 36 problems that people should be warned about. You can go on the website, that's aalm.info, aalm.info. You'll see it right there on the opening page, and you can download it. And you're free to distribute it to anybody you want to distribute it to. I wrote it, I own the copyright. Next slide. Marijuana is a medicine, or is it use malpractice? I think for reasons which I've talked about, and there's a little more, clarity on this, on whether it's malpractice or not. Again, consult the risks of marijuana put up by Next slide. Why is marijuana not as a good medicine? These are questions about marijuana that have not been answered for the conditions that marijuana as medicine is legalized for under state law. There is very little evidence about the effectiveness, the risks, the benefits. Dosage is a big issue. How many joints do you smoke to provide a proper dosage for somebody that's got Crohn's disease? There's no evidence. There's no science backing any of that up. You all know when you get a medicine from the pharmacy, tells you exactly when to take it, what time of day to take it with food, without food. None of that's going on with marijuana as a medicine. And also, what are the other alternatives? Age also affects dosage. None of that's going on right now. The marijuana industry is low-hanging fruit for personal injury lawyers. Next slide. And we get into the whole issue of dosing. We don't know what frequency is, duration, time of administration, meals, time and onset of symptoms, route or method of administration, or age or sex. Dosing can depend on your sex. It can depend on your age. It can depend on other medicines that you're using. Next slide. These are all of the risks, and I've covered these already. I'm trying to go through this rather quickly. I think I've covered all these. Next slide, about other risks of medical marijuana. Now, there are other, next slide, that says other malpractice claims. Once you give somebody to marijuana, you then you should follow up to make sure that things are going well and not going well. So failure to detect marijuana's side effects, failure to keep up to date on the science, to be aware of contraindications, failure to have a proper medical examination, allowing patients to become exhausted, and so forth, and failure to monitor. These are all other malpractice claims that can be brought in with marijuana as medicine. Next slide. Failure to properly label. This is a big problem across the country. The products are not properly labeled. They're not even doing as much as when you go out and buy potato chips, it tells you what's in the potato chips. That gives you all kinds of data about it. They're not doing anything. The only thing they say is there may be THC in it. They may have a very brief warning about something, but it is grossly negligent not to properly label marijuana. Next slide. Contamination, believe it or not, is a big issue. We have case after case after case of examples, even in states that are in quotes regulated, and they're really not, of citations for contamination. Now, the problem with this is that all these contaminants are coming into people's bodies by smoking and vaping, or being ingested in food and drinks. Kids are getting this stuff because of being in rooms where parents are smoking marijuana. This again is something that has been completely overlooked. For example, in Colorado, there's a class action suit that they were using a pesticide called Eagle 20, which turns into cyanide when it's heated. Okay, and that's the kind of things that are going on. Next slide. Now, third-party endangerment. This is a cause of action where if you give somebody an intoxicating substance and they go out and injure somebody else because they were intoxicated, you can be held responsible for that. So the doctor that gives somebody marijuana negligently and that person leaves and goes out and gets high and damages somebody, that doctor could be caused. Marinol, which is an FDA-approved synthetic THC, has this warning: do not drive, operate machinery, or do other dangerous activities until you know how marijuana affects you. That is not happening with other medical marijuana. Marinol is approved by the FDA. They have a whole package insert in there which tells you all kinds of information about Marinol, how to use it, when not to use it, and so forth. None of this is going on with medical marijuana in the States. Next slide. Loss of chance doctrine is where you can sue a doctor because the doctor gave somebody marijuana instead of giving them a conventional or proven safe and effective medicine, and they died or got injured because of that. That's called loss of chance of doctrine. You lost your chance to get well because you relied on this doctor's advice who gave you a medicine that actually was harmful. Next slide. Aggravation of a pre-existing condition. If you've got a depressive condition, under no circumstances should you be given marijuana. If you have anxiety, you shouldn't be given marijuana. And yet, it is one of the leading causes of people getting medical marijuana in Kentucky is anxiety. Marijuana causes anxiety. It causes mental illness, and it will actually aggravate those conditions. Next slide. Environmental cases, the states where they have outdoor marijuana growing, there is very poor regulation of pesticides, heavy metals, water contamination, wildlife deaths. Americans Against Legalizing Marijuana has put out a paper called The Water, Wildlife, or Weed, documenting that a lot of animals in the outdoor growing marijuana states are being killed because of marijuana growing and running off into the environment. Server liability. This is where you go to a marijuana store and they give you marijuana. They don't warn you about it. We have places now, they're trying to get this in New Jersey, of what are called smoking lounges where you can go and smoke pot. Okay, they have it in Connecticut, for example, and other states. So anybody running one of those places who's watching somebody get stoned could be liable for what they do when they leave the place. The difference between alcohol and marijuana is you can have one glass of alcohol and not get intoxicated. You can have one joint and you're going to get intoxicated. It doesn't work like alcohol. So I think there should be more cases for server liability. There's the Drug Dealer Liability Act. Several states have this, about 15. You only have to prove if your plaintiff was damaged by marijuana, you only have to prove that the defendant, the person you're suing, was distributing illegal drugs or marijuana in the community. You don't have to prove that that particular person did it. So this is extremely effective in the states that have not legalized marijuana, have a Drug Dealer Liability Act. Now, Drug Dealer Liability Act clients are guardians of drug babies that have been affected by drugs, those injured by drug drivers, employers, hospitals that have to pay for the treatment, parents of children in drug treatment, and state and county public agencies that pay for drug treatment and insurers. Next slide. I want to make sure that I am going to just end really quickly now. If you have a marijuana operation near you and it's damaging your property values, you can file a RICO lawsuit. This is attractive for lawyers because lawyers can get their fees paid and you can get triple damages. So I'm going to go through now, go to the next slide and then go to the slide that says marijuana industry defenses. They can defend themselves by saying that you knew the risk of marijuana and you went and did it anyway, that you engaged in wrongful conduct, say you got the marijuana illegally. They can claim that, well, you were addicted, it's not our fault. They can claim that you were comparatively negligent, that you abused the product, and so forth. Next slide. They can claim that there was superseding active negligence by the medical care provider, that marijuana is unsafe, but it was useful and had proper warnings. And there's other defenses that they may have. Next slide. We're engaging right now in litigation against the government of New York. We're about to file a lawsuit against the government of Minnesota for their actions in passing marijuana laws. If you are in a state and you would like to sue the state over your marijuana laws, please get in touch with us. We have the briefs, we have everything available to you. The only thing that we're limited in right now is funding. If you can find funding for it, we'd be happy to help you. These are examples of more information you get on marijuana and the law. You can go on the CIVEL website, which is www.civel.org, and then other resources that keep going. Next slide that Aubrey mentioned. Now, go to the slide that says, what can CIVEL do to help you? We can help draft complaints. We can help obtain experts. We can help draft discovery. We can provide legal research. We can help in obtaining scientific research. We can help with publicity. We do not charge for our services. We will not charge you or your lawyer for our services. The only thing we would charge is if you asked us to come up with some complicated legal research like a brief, we might ask for some compensation for that. Now, my lawyer tells me I have to say this. I'm only licensed to practice law in New Jersey. This presentation should not be considered legal or medical advice. It's for informational purposes only. It does not create an attorney-client relationship between me and you. If you want advice on law, consult an attorney licensed in your state. So now I'd like to introduce George Hritz, who is going to talk about a very important issue concerning evidence. So George will talk for about 15 minutes, and then we'll have Aaron talk for about 5, and that'll leave us some time for questions. Thank you.
Thanks, Dave. I'm George Hritz, and this is the marriage between Dave and me. A collaboration is made in heaven, because I've spent most of my career doing discovery. And we used to joke in my old firms that we should be admitted to the American College of Pretrial Lawyers, because one of the most famous lawyers organization is called the American College of Trial Lawyers. But we never get to trial, and we represented mostly defendants. And back in the old days when I represented most defendants about 30 or 40 years ago, I had 4 houses and no mortgages. It's a little different these days. My wife keeps asking me when it is we're going to be able to retire, and she's now working too. But this is fun, and it is important work, and that's one of the reasons why it's fun for us to do. I have a brother who used to come and visit me, and when we lived in Tribeca in Lower Manhattan, and he used to go out at night and go up to the West Village and come back stoned, and he lived to be 33 years old. And he was basically married to a guy in Washington And they fooled around, and we know what they're doing, but we were too politically correct to say anything about it because we thought, well, marijuana is harmless. But we have many of the people on this call have been affected negatively by what a huge number of other people think are harmless. And one of the things, the consequences of thinking that is harmless is that people don't save evidence. And this is a big advantage to the defense. And it's a big advantage to defense lawyers like I used to be. And that is that it's hard to prove. Dave reminded me before, and Dave's done a lot of work on this, and he's a plaintiff's lawyer who's savvy to a lot of this stuff. And hopefully in the next couple of months, we'll be able to develop, or I'll be able to develop, maybe he already has it, but a set of slides that are as wonderful and as comprehensive as the ones that he used with you. But, the important thing in discovery is coming up with evidence. And many people have wonderful cases against marijuana manufacturers, against doctors, against, all sorts of people. And they didn't save their credit card receipts. They didn't save warnings. They didn't save links that they were aware of. They didn't save, evidence of the advice or lack of advice that they got from doctors. They don't know which pot stores they were supplied by, and these pot stores are, now becoming legal in all sorts of different states, especially in New York. They're being run by people who are not necessarily the most responsible citizens in the first place. And one of my friends, who's a doctor and a lawyer, took his son in for a birthday dinner the other day in Manhattan. We live in Connecticut now. They went into Manhattan, and he said that you wouldn't believe the length of the lines outside the pot stores. And my friends who still live in Manhattan, as I did for 25 years, tell me that the smell is all over the city. And, the evidence of all that needs to be, it's so universal that it makes it really difficult to prosecute. So I'm going to go through some of the things that we have to prepare for, and some of the work that we have to do to develop a case on the plaintiff side, because the defense lawyers are going to be very active in trying to figure out, how to defeat all of these claims. So you have to remember that the plaintiff has the burden of proving a case, and so they also have the the burden of obtaining discovery.
And George, I think you're back on. We're so sorry we lost you. And I don't know why it says Dave Evans down by your name, but we look forward to hearing more from you. You can go ahead and speak, and I'll try to rename you here.
Okay. Well, can you hear me now?
Yes, we can hear you.
Oh, good. Okay, good. Well, I'm going to try to cut through this. And I apologize. By the time that we do this next one, I'll try to have a set of slides that is as well organized as Dave's were. As I mentioned, I'm not sure where I was cut off, but can you tell me the last thing or two you remember that I said?
Yeah, you just talked about not having receipts and
okay.
Evidence, that kind of thing, and because in order to sue somebody, we have to know who to sue.
Right, absolutely. Okay, so there is a false perception, as Dave mentioned, that marijuana is harmless, and as a result, people's beginning to get addicted is a difficult perception for people to understand right away. In alcoholism, and also it's a question of experience. There are many years, maybe almost 100 years now, of concentration in 12-step programs for alcohol and other kind of drug recovery, but very little. In fact, I just learned yesterday that there is a 12-step program for marijuana users. I had no idea. And this has been a very successful thing. My wife and I had a nephew who was in a faith-based recovery program about 10 years ago. And he got kicked out of 8th grade for taking some kind of drugs. I'm not sure what it was. And he had been through a series of trauma, including his parents' divorce. And he said to us must have been about 15 years old. He'd been in this program for about 15 months. And he said, my father always said, if you can't live by the rules of this house, go live with your mother. My mother always said, if you can't live by the rules of this house, go live with your father. Can I come live with you? And we looked at each other and said, okay. And he ended up graduating from Greenwich High School with straight A's, 2 varsity letters, a year ahead of his class. He then went out west to become a rancher for a couple of years. And he called us last spring and said he'd gotten into law school. And no, 2 springs ago, because he's now a second-year law student. And it is possible for people to recover from alcohol and some kinds of drug use, but there is a lack of study and awareness of how long, and what effective ways there are for treating marijuana abuse. And the need is to just collect all sorts of evidence that you wouldn't assume you need, but you do. For example, when in a lawsuit against dispensaries, we need documents on guidance to dispensary employees or sales representatives to cover up the side effects. Documents between organizations. There are going to be all sorts of today, Dave and I sent out a letter to the state of New York and their attorney general's office and all of the people that they represent, asking them to preserve 12 pages of documents, single-spaced, that they need to preserve, including electronic evidence. And hopefully, if we get past the motion to dismiss, we're going to have all sorts of evidence, including communications between the kinds of people applying for hot licenses and the state organizations. All of these are documents that we know they have, and we need to see them and to see what people are saying, and to see what people are saying in evidence about the effects that pot has had on people, including these people who are going to get priorities to do to open these, to get licenses. And we're now facing a huge financial machine on the other side. It's now no longer just individual pot stores or dealers who are dealing marijuana on the street, but it is investment bankers who are funding these stores. There are all sorts of people who have all sorts of documents that will show, what issues are involved here that we can take advantage of on the plaintiff side, the same way that my clients and I used to take advantage of people on the defense side. The good news for us is that the individuals and organizations that we represent have very little information that could hurt us, because there is not information, positive information about marijuana. The evidence is pretty much all on the other side. In states where marijuana has been legalized, there may be state agency records. There are records about patients, licenses, medical care providers. There's sets of document interrogatories. You don't need to worry about these so much. That's our job as lawyers to do. But all of these things are being crafted. Dave has been working on them for years. He is my mentor, and he's teaching me what we need and what we have to develop, what kinds of information we're looking for. We are going to need to collect information on the side effects, the diagnoses, the treatments that were given, studies that people have that can't possibly be positive. And if they are, our experts will be able to pick them apart. So more interesting for you, I think, is the substance of the issue, the kinds of things that Dave has described. But it's our job to collect the evidence and do the boring part of picking through that and coming up with things and making ways of proving these cases if they go to trial, because there is a lot of a lack of documentation available if people don't know they need to preserve it. So that's really all I want to say today. I could, we'll have a more sophisticated set of slides and things worked out as we go along, but we need to collect more. We need to be able to answer your questions, and we need all of you to help in going out and telling us what kinds of things that you have or people who are plaintiffs have that could help us prove these cases. Thanks.
Aaron, go ahead.
Okay.
We welcome you. Why don't you go ahead and take the floor?
Thank you, Aubrey. I want to thank Dave and obviously George. My name is Aaron Kress. I'm a New Mexico attorney. I live in Albuquerque with my family. I practice walk-in law, which means I'll take just about any case that walks in. That's not exactly true. I'm pretty selective actually about the cases I take, but I'm able to work in numerous areas of practice, and I mostly do civil plaintiffs work. I've done some criminal defense. I was impacted by marijuana from a young age. My family was impacted by marijuana. I'll spare you all the details. I think a lot of you guys in the audience probably know what's going on here. And I'm trying to organize a federal class action lawsuit against some of the big players in the marijuana industry, some of the big companies, which I'd like to file in the Federal District of Colorado. Now, I should be clear what this case has the potential to accomplish and what it will not accomplish. Okay, so what it will not accomplish is it's not likely to shut down the marijuana industry. It's not likely to result in the reversal of state laws, legislation at the state level legalizing pot. And a class action is not suitable for certain types of claims. So since I put out the word to Dave and George and Aubrey, and they've distributed my letter that describes the types of people that would be suitable lead plaintiffs for this case, I've gotten a number of responses from people whose loved ones committed suicide as a result of cannabis psychosis or other mental illness arising from the use of marijuana. Those claims are essentially wrongful death claims. Wrongful death claims are, if they're worth anything, they're worth a lot. And you would not want to subsume your wrongful death claim into a class action, okay? Because to be a member of a class, you're going to get a smaller amount in recovery, whether it's in a settlement or in a jury award, because that lump sum has to be distributed among so many members of the class. So there are lots of claims where you wouldn't want to subsume that into a class action. If you are living in a small town and you've got a dispensary down the street that persists in selling marijuana to your loved one, when that person is visibly suffering from psychotic symptoms, you may have an individual claim against that dispensor that you would not want to subsume into a nationwide class action, right? And I have to say that right up front, because it's very important people know if they have a claim that's not suitable to be subsumed into a class action. Now, the causes of action that I intend to move under Dave mentioned some of them. I think he mentioned every possible cause of action, actually. So Colorado has a good drug dealer liability statute. And by the way, bringing a class action in federal court, as Dave mentioned, if you raise a federal question, you move under a federal cause of action. That brings it into federal court. And then there's also the diversity doctrine, which means that if you have diversity of citizenship, in other words, no defendant is a citizen of the same state as any plaintiff, and the amount in controversy is above a certain high figure, then you can bring your claim into federal court. Now, with a class action, diversity is a little bit different. The courts aren't as stringent in insisting that all of the plaintiffs be from different states than all of the defendants. But the causes of action I'd like to assert are drug dealer liability, false advertising, essentially, under Colorado's Unfair Trade Practices Act, and negligent failure to warn. And the plaintiffs I'm looking for would be individuals who have suffered from one of primarily two disorders. Those would be cannabis use disorder and cannabis psychosis. Again, some people may have individual claims that would be stronger than claims subsumed into a class action. But I think that so many people are impacted by this that it is ripe for a class action. And again, the parameters for lead plaintiffs would be if you have suffered cannabis psychosis or use disorder. And I'm also looking into asserting claims on behalf of those who have suffered cannabinoid hyperemesis syndrome. That was something I didn't know existed until the other day. So I had put out my letter to Aubrey and Dave before I was aware of that. But primarily we're looking at psychosis and use disorder. And, you know, becoming a lead plaintiff in a class action is a commitment, right? So if you've got a loved one who was diagnosed with, and you'd need to be diagnosed to bring a claim. If you've got a loved one who's diagnosed with use disorder and they've gotten out of rehab and everything looked okay, and then they started using again, you might not be a reliable person to act as a lead plaintiff in a class action. It doesn't cost anything to be a lead plaintiff, but you may be deposed. You may have to give testimony in open court. And you have to meet the requirements under federal law to, you know, adequately represent a class of people. Part of that requirement is that you have to have chosen competent counsel. And that opens up the door for other lead plaintiffs or potential lead plaintiffs to come in and say, no, we would be better representatives of the class. Right. So in order to fend that off, I plan on bringing more experienced colleagues in to help me with the case, to put their names on it. The other thing about being a lead plaintiff is you could have unwanted publicity. You could have media scrutiny. So, you know, people have to be aware of all that, and you have to consult with your attorneys throughout, you know, what could be a years-long process. But an ideal lead plaintiff would be somebody who, within Colorado's statute of limitations, which is for each of the three claims I mentioned, there are differing statutes of limitations, but the smallest one, the lesser of the three, is a 2-year statute of limitations. So if within the last 2 years you or a loved one has suffered from cannabis psychosis that you were diagnosed with by a medical professional, preferably by a physician, or cannabis use disorder, you may be a suitable candidate to be a lead plaintiff, keeping in mind the challenges that presents and the commitment that represents that I just mentioned. So, you know, this case is in its very incipient stages. It doesn't exist yet. And I need to find lead plaintiffs who would be willing to act as lead plaintiffs with all that goes along with that, as I've just described. So, and I'll put my contact information in the comments right now in case anybody wants to get in touch. I'm finding it difficult to field all the phone calls. So maybe just, I'll just put my email address and you can get in touch with me that way. But people are welcome to call and I'll do my best to get back to everyone. So I'm putting my contact info in the comments right now. And that's all I've got. Aubrey, Dave, George, thank you very much. And thank you everyone in the audience.
Thank you, Aaron. Contact me. Well, maybe we can fill out a form or figure out some kind of system for you to help navigate those people that are contacting you. We can help support you on that. And thank you for doing this. Thank you so
Aubrey,
much.
do we have time for questions? I know we're supposed to end at 2, but do we have time for questions?
Yeah, so let me just first of all thank you three for being here, Dave, George, and Aaron. This was powerful. This was necessary information. It makes me want to tear up that we're at this point, that so many families have been harmed, and our government officials have gotten away with so much. I just want to thank you very much from the bottom of my heart. And we know this is just the beginning. And we know that we can support you at Every Brain Matters. I know there's other organizations that can support you to help organize your efforts and advocate for your work. So thank you for being here. I would say we understand if people need to sign off at this point, if you need to get back to your work days, your families. We know a lot of you are advocating and taking care of your loved ones that have been impacted by the negative effects of marijuana. And I think the best way to navigate questions at this point is to raise your hand and we'll call on you, because the chat seemed like it was pretty active during the whole presentation. So please raise your hand if you have a question. Please try to get to the point when you do ask the question, so we can be mindful of Dave and George and Aaron's time. And if any of you need to leave, we understand. We could do this again. This is not the end of it. This is just the beginning. So yes, let's go ahead and navigate some questions. And I see Dr. Christine Miller's hand is up first. So Dr. Miller, welcome.
Hi, yes, thank you for excellent presentation. I have some questions based on the families that I've been in touch with. You know, I'm a neuroscientist and I testify in Maryland all the time about the harms of pot to the legislature, and I've been approached by families. The big thing is the statute of limitations. There is one case I know, particularly when it pertains to medical marijuana, but not just medical, where the harm is ongoing. So the first episode of psychosis, you know, was 3.5 years ago, but he still has his medical marijuana card. And so the harm is ongoing. And I wonder what the statute of limitations has to say about that, because the harm was yesterday, you know, it's continuing. The other question I have is, when you're dealing with mental health harms, it is very hard to get a reliable adult plaintiff who can handle the case, you know, being on trial. And so this one family I know of in particular, there is no way that their son even wants to bring a lawsuit. I mean, he still thinks marijuana is great, but he's psychotic and he will never recover at this point, we're convinced. So the issue is, you know, what can the family do as other than becoming his guardian, which is a very difficult process to go through in the state of Maryland. You know, what type of suit could they bring? I mean, I was trying to help them find out if, you know, loss of consortium might be a possibility, because they have essentially lost the ability to have the family relationship with this young man. He used to babysit his nieces. They are scared to death of him now. He was violent while he, you know, at his peak psychosis, he can be very violent. And so you're facing a situation where, you know, if the psychosis comes on at age 18, then what are you going to do? Because, you know, the families cannot, under most circumstances, bring the lawsuit, and the person who is affected can't really bring it either.
That's statute of limitations are really a function of state law, particularly with medical malpractice. And there may be limitations on medical malpractice in terms of statute of limitations. There may be limitations on damages you can receive. In New Jersey, for example, you have to, when you file a complaint within 90 days, you also have to file an expert report that malpractice occurred, even before you've done any discovery. So you'd have to consult with an attorney, a personal injury attorney in the state. There are a number of states that do have commitment laws that can be used. In New Jersey, you can commit your child under the Family Law Act. That's a law that I was involved in passing a couple of decades ago. In other states like Louisiana, any family member can file to get somebody committed or to get guardianship over them. But again, that's a function of state law. And it is not often used. I am familiar also with the phenomenon of people who are addicted to marijuana don't want any help and failing to recognize what it is. So we may have to change some laws in some states, but again, get a lawyer that can research that particular state's law. Every state has some process for committing somebody for mental illness. We have a case in Florida right now where the judges in a county just aren't doing it, but judges in another county are. We have an attorney who's on this website, on this, is it Mr. Considine? Who may be able to be helpful. If he'll put his contact information on the chat, he could give us some advice. I don't know if George or Aaron have any comments on that.
I have a comment, sort of a non-legal comment, and that is, I know with respect to alcohol and drug abuse, there are intervention, there are people who are really skilled at intervening. Usually it involves a combination of the family members affected by the person using the drug or alcohol, or in this case, marijuana. There probably needs to be the development of a stronger and more publicization, because I'd never heard of that. There was a, I don't know what you would call it. It's like a sort of marijuana AA, and that people do, just as Dave said, they don't want to get treatment. They don't think they need it. But if enough of people who really care about them, who they know care about them, and an expert at doing that get together with them, sometimes it can be effective.
What is
Aaron, do you have any comments? Aaron, you're muted.
No comment. I would second what Dave and George have already said.
Okay, the other thing that I would recommend is if there's a basis for a criminal charge, have the family file a criminal charge against the person. Because with criminal charges, treatment can be mandated. And any threats, you know, I'm going to kill you, anything like that, is a criminal act. My brother, before he recovered from alcoholism, faced me calling up his employer and turning him in for drunken driving. And my brother's been sober, I don't know, 30 years now. So I'm a big advocate of using the criminal justice system. Domestic violence includes family members. It's not just male-female stuff. It can include family members under state law. In New Jersey, for juveniles, if there's a juvenile family crisis where the juvenile is not behaving, the parents and so forth, you can file a complaint in court and have the juvenile forced into treatment, and including the family if you need to. So there are options that are out there. It would just depend on state by state.
And that was, by the way, that's what happened in the case of my nephew. My wife and his mother got together and had him, he was under 18. So he was taken away by two Chicago cops who put plastic handcuffs on him, and they sent him to a treatment center. Not a state, he actually went to we've done some studies about this. The NIH put out a letter, an article that said that faith-based treatment centers had an 80% success rate, and state-based treatment centers had about a 20%. But you know, even 20% is better, and 80% is certainly a lot better than being addicted.
But all these interventions.
Yeah, the other thing is we have experts that are available. Dr. Miller, we'd love to have you added to our list of experts. You have my email. If you send me your CV, we will recommend you as an expert in these cases.
Thank you. I'm happy to send you my CV. All these approaches of interventions don't address the who's to blame part, which is really the cannabis industry, the medical marijuana doctors that recommend it. And so, the parents filing criminal charges against their child is so unlikely to happen when they really have tremendous anger towards the cannabis industry and the medical cannabis doctors. So that's the issue. I mean, these people wanted to file lawsuits. I contacted 10 lawyers from academic institutions to various private practices around Maryland. None of them would take the case because the affected person is an adult. He's incompetent to bring a case himself. He won't sign the paperwork, with any knowing consent. And so that's, I'm afraid, what you're going to face. Is the vast majority of people who end up coming to you are going to be families who have someone who may have been a teenager when this started, but are now adults.
Those are such good points, Dr. Miller. More meetings like this to discuss those avenues to support the families to get avenues for accountability and treatment. So you're so right when you say all that. So thank you. Let's go to Peggy Walker next. Do you have a question?
Yes, thank you. I was listening, and it sounds like the medical malpractice cases are difficult because they have to come from basically the individual. But what about the Federal Trade Commission, for example, prohibits deceptive advertising in commerce? Is there any way to bring down some of these activities through those laws, deceptive advertising in commerce? For example, all these products that are designed to appeal to children are really deceptive advertising in commerce. But could there be class action suits for deceptive advertising as medical or as medicine, or deceptive commerce, anything along those lines, where it wouldn't have to come from just the individual impacted?
So I can address that. As far as the Federal Trade Commission Act, that does not create a private cause of action. So there would be no federal cause of action that I know of for false advertising, unless you're another marijuana business that's being harmed by false advertising by your competitor. And we're not here to represent them. So, but the class action that I'm preparing would be, one of the claims would be false advertising, deceptive trade practices under state law. And to the extent that, and by the way, I'm not planning to go after the medical cannabis side of things. This would be against the recreational industry. And so to the extent that any medical marijuana, purported medical marijuana is being advertised this way or that, the class action I'm trying to organize would not touch that. We would look at the recreational side and say, okay, if you look at the websites of the big manufacturers, they say this is a wellness product, right? And so they're using very general terms. They're not claiming that it cures anything specific, but they're saying that it's good for you. And that's deceptive in and of itself. So those kinds of things are very conducive to class action deceptive trade practices claims. But at the state law level. And again, to bring a state in federal court, requires that the claim be for a certain amount of money, and that the plaintiffs be from different states than the defendants.
I believe that there are some federal laws that may apply to false claims and false advertising under RICO in particular. So if somebody has that concern, they can contact me and we can do that. The way that they got the tobacco companies under RICO was mail and wire fraud. So those types of claims could be used. As far as, yeah, go ahead.
Well, I would caution about the use of RICO in these cases because what might, I don't say that it's bad. It could be very useful, but a lot of these companies, so the big marijuana manufacturer is Curaleaf, for example, and they are operating a web of shell subsidiaries in order to comply with state laws that forbid them to operate in interstate commerce. So you've got a nationwide company that has 15, 20, 30 LLCs that they've registered in various states. And so, you know, a RICO claim would have to take that into account, that they are oftentimes very careful to operate within, strictly within state law. And so you'd have to sort of tease out a legal theory that shows that they're operating in interstate commerce or through I think that RICO, civil RICO is, you know, deception through, it's like wire fraud, you know, through the mails, through the internet. So you'd have to hone in on that.
Yeah, there is case law that all of it is involved in interstate commerce. There was just a decision in New York, which we're using in our lawsuit, the Verisign case, where a out-of-state marijuana company wanted to go to New York, and it was held that they could do it under the Commerce Clause. The U.S. Supreme Court in Gonzalez versus Race said that that it is a matter of interstate commerce. So these are things that should be explored. And the difficulty with getting lawyers is that there haven't been any big judgments yet. Okay. As soon as somebody gets a big judgment and it gets publicized, all of a sudden lawyers are going to become very interested in this. We had the same problem in Michigan finding a lawyer. That is what we're looking for, to educate attorneys and to make them aware that there is low-hanging fruit here.
Thank you.
But Aaron is correct that you do have to do a lot of research, and that's why it's a good idea to get a lawyer that's thoughtful and diligent.
Okay. All right, let's go on to the next question. Linda Wolf, do you have a question?
Hi, yes, I do. I still get kind of emotional about all this. Aubrey knows I've been through this with her for 2 years, over 2 years. Kobe hasn't smoked weed for over a year. But it was absolute hell. It was absolute hell what we went through for 2 years. And I worked in the court system for 14 years. I know kind of how it works with the law as far as calling the police, kind of forming a case and getting them into a hospital. Well, I've done it 3 times, and it's really hard to do when they're over the age of 18. We started at 19. And so we do have everything documented with 911 calls, with the police, I called the county attorney, talked to her to help get him in, to get him committed. And the weed was all it was. It was all weed. It was 100% weed. And my husband is an attorney too. And he, you know, he really didn't know what to do. It was just so hard. It was so bad. And when I called Aubrey, we did get all the help we needed and started on the right track and did what we had to do. But, you know, it was so stressful on our family that, I mean, I have 3 other boys and they were all stressed. Gary and I both ended up in the ER at different times for stress things that happened, and tracking him down. And it was a long story, but he was in 3 separate hospitals, and we each time had to get him involuntarily committed. And that was hard. And he was, you know, diagnosed with cannabis-induced psychosis every single time. And he's fine now. He's fine now. But they did the third diagnosis was cannabis-induced psychosis. But then they thought, well, since it's 3 times now, because he did not buy that it was weed that was doing this to him. He did not think it was. Now he does, but he didn't. And he finally, the 3rd time that the same doctor said, Linda, I don't really know for sure, but I'm going to go ahead and put bipolar on it this time because I really don't know. He said it's so new that he sees psychosis a lot with cannabis. but it acts like bipolar. It acts like schizophrenia. It acts terrible. He's walking around out of his mind, walking around on the street like he's got schizophrenia, but he doesn't. He didn't, and he's fine now. He's fine. He doesn't have. He's fine, and he's working full time. You know, he's doing good. And by the way, my nephew started smoking weed at 35, or you know, he went to college, played college football in California. He was a good athlete, and in his 30s, he started smoking a lot of weed. He got so depressed. This just happened about 3 weeks ago. He got so depressed, he went and jumped in front of a train and lost his leg. He kind of changed his mind in the midst of it, and he lost his leg, but he lived. And I know it was from smoking a lot of weed. I believe that. It's just so awful what it does. And now my sister-in-law and brother-in-law are dealing with all of this. It's just terrible what they have to go through. And I don't know. I just wish there was something that could be done. I wish there was something more that could be done, because Kobe started when he was in high school, you know, getting a marijuana card in high school. It's insane what's going on. It really is. I
Well,
guess
it's clear that we have a lot of work to do with education, and that's one of the reasons for doing lawsuits, is they can be very educational and get a lot of publicity. And so that's, you know, I've like I said, I've lost my faith in government to deal with this right now. I think it's up to lawyers and plaintiffs to bring this to public attention.
Yeah, and we feel your pain and your frustration, Linda, and know that there's been a core group of us working really hard for many years trying to push back on this, and this meeting right here is even a huge step. So thank you for sharing, and I'm sending you a lot of love. Let's go ahead to Esther Miller next.
Hi guys, my name is Esther Miller. I work for Drug Free Business. We of course help employers keep employees drug free, which we hope kind of trickles down to their families and our communities. I had two questions real quickly. Number one is, will this presentation be available so that I have a copy of it? I could share it with colleagues. And then the other thing is I would really love to have one of you folks join us, the group of people that I work with in the employment field, and just talk about your talk about exactly these things, because I think a lot of people, they're on the fence about marijuana. They think, oh yeah, well, we've got to test for it, but gosh, it's just not that bad of a deal. And, you know, so they minimize, employers do this too. They really minimize the dangers, they minimize the health hazards. And, you know, you would be preaching to the choir for sure, but at least the information, the education would be getting out, and you'd be getting it out to a whole different audience, which would be employers. And I think that's important too, because employers exercise a lot of control over what happens in the workplace, and how, you know, people who use marijuana are treated. So that's my two questions. Thanks.
Well, Esther, if you get a hold of me, I've done a lot of work in that area, and I can be helpful to you. I've written I have two books on employee assistance programs and what employers can do with drug testing and so forth. So, you know, my email is on the, and you know, I can help you with that.
Yeah,
I've got tons of information.
Great.
We'll send up a follow-up email with the contact information with Dave, Aaron, and George, and the slides, and this is being recorded, and they have given me permission to upload it to the Every Brain Matters YouTube channel. So
Oh, nice.
Join Every Brain Matters, subscribe to the YouTube channel, sign up for our newsletters, because you'll get updates through the newsletters every month too. And thank you for what you do, Esther. Thank you for your question.
Well, thank you guys. I'm thrilled to hear that, you know, somebody's maybe going to be held accountable for this stuff. So, and I'm sorry, but I do have to leave, but thank you.
Thank you for joining us. Andrew Woodlock, It's so good to see you.
Yeah, hi everybody, and thanks to one and all of you for your work. Just a quick question. Here in, I'm living in New York in a small county, small town. We were presented with these kind of one and done laws with regard to dispensaries that they were explained to us as you can opt into having a dispensary in your town. And once you opt in, there is no going back. There's no way to take those laws away. But if you opted out, you could revisit it later. I've just never heard of these kind of one and done laws like this. And is there any ways to challenge these dispensary laws? Because it like I said, it seemed very odd to me, the whole.
We have a lawsuit going in New York. I'm in New Jersey right now. It does exactly that. And has the marijuana trafficking store already been set up in your town?
Not yet. They're
Okay.
supposed to be going into
We're
effect, I think,
also-
Tuesday.
We're also very helpful in stopping them from getting into towns. My organization, Cannabis Industry Victims Educating Litigators, we have a whole process for that. As a matter of fact, we're helping, George and I are now helping Stanford,
Okay.
CIVEL.org. George and I are helping Stamford, Connecticut resist dispensaries right now. And then we have a lawsuit going in New Jersey. So we'd be happy to work with you.
Great. Thank you.
Thank you, Andrew. Okay, we'll go to Bart and then we'll go to Renee next. Thank you for your question.
Oh, hi. Yeah, a fantastic presentation. Thank you. So in May of 2022, a friend of mine lives right next to a park, and lots of, he said, teenagers, he said, estimated the ages were like 15 to 18 years old, were partying, and then they get in their car and they drove away, and they're partying almost exclusively on Stizzy products. Stizzy is a big dispensary or pot shop in our small town. And so afterwards, he picked up tons of wrappers and vapes and vape pens and all that. And some of them had Stizzy on it, and their product name and all that. Is there anything that's from May of 2022, anything that can be done legally with that or not?
I had sort of bad sound that I didn't quite hear some of the stuff that you were saying.
So yeah, long story short, a bunch of underage kids, 18 and under, were partying with using a lot of pot products. And we have a pot shop in Benicia, our little town, and they left a lot of the wrappers that said Stizzy, which is the pot shop, and other products like that. And so we picked them all up, and I don't have them right now, but a good friend of mine has all that. And just wanted to see if there's anything. They got in their cars and drove away. I don't know if there's anything that can be done with that legally.
Well, I mean, I would certainly report it to law enforcement. If you can contact their parents, potentially you could file an action against the store. The state marijuana regulatory people may actually be helpful if I don't think any state permits it for underage people. Maybe they would seek sanctions against the store. I would turn them in.
Okay.
All right. Is this in?
I have no, you have to be aggressive with these people. It's been my experience. And you have to make it clear that this is unacceptable. Because they're hearing from the pot industry all the time about what great guys they are in dispensing pot. And they need to hear from the public. I'm stunned by how ignorant people in the marijuana industry are about marijuana. They're just ignorant about it, and they don't understand what they're doing half the time.
Okay, thank you.
Thank you, Bart. Renee?
First, I want to thank you. I'm named in your lawsuit, and I really appreciate what you're doing in New York. And two quick questions. One is there a way to sue for normalization? Because if you have pot shops in downtown Main Street, you're normalizing the drug. And the other question is, we have a hemp shop. We've opted out. Now, if we opted out, we shouldn't have a hemp shop.
Well, yeah, I mean, that's what we're trying to do in New Jersey is we're suing a town there that put in pot stores. Most towns do not, when they're given the option, do not have pot stores. I mean, the majority of the municipalities in New York opted out. 71% of them opted out in New Jersey because we sued in the state of New Jersey at the time, that delayed implementation that gave us a chance to contact municipalities. 71% opted out. We're still helping people to opt out. You know, one of the things that I do, and I'd be happy to do this anywhere in the country, is I call it a shitgram, sending a shitgram to your local officials, telling them what they're doing violates federal law, what's wrong with what they're doing, the liabilities for what they're doing. I have a legal primer which I send out to them. I'm very aggressive about this. And sometimes I've turned them into the US Attorney's Office or the FBI. And I let them know all this. And this is all news to a lot of these people. They have no idea that what they're doing was anything wrong. And then follow up with a series of emails, and particularly with local people who then back me up and do it. And we've had remarkable success in keeping them out of towns based on that approach. But you need people aggressive in the town who keep emailing them, contacting them, showing up at public meetings. I threaten them with hellfire and you know, give people information. I've got tons of one-pagers on what's wrong with marijuana legalization, the dangers of marijuana legalization. We just stopped medical marijuana in North Carolina. I sent letters out to the entire legislature every couple of days. I kept giving them a lot of information. Information does work. You have to just understand these people are ignorant. They don't understand what is going on. And once they hear about it, you know, they start changing the law. We've been successful in New Jersey. We only failed in one town in New Jersey to stop the pot store from going in there, and we're currently suing that town. So you got to be aggressive about this. You got to be aggressive about it. Take no prisoners. These people are hurting people. They're criminals on the federal level, and we should let everybody know it's unacceptable.
And for clarity's sake, Dave, let's define aggression. We're not saying physical aggression or any kind of violence. We're saying
No. I always tell her, thank you for bringing that up. I always tell people to be very polite and professional, but don't, you know, accept excuses. Everything they throw at you, we have an answer for. You know, particularly this thing about Black people going to prison for possession of small amounts of marijuana. It's just a myth. It's not true. We did the study. It's just not true. You know, we're happy to take them on at any time with any of these arguments.
Dave is a powerful, assertive advocate. If you ever get a chance to watch him in action, I guarantee you will call him your hero. He's amazing.
Well, stories are what's important. So we use stories and George knows the value of this. We have handouts to legislators about, Sally is on this call, about her son. You know, with photographs of people that have been killed because of marijuana. And those are the types of things that we need to help make our case. In our New York lawsuit, we're including stories about mothers and caretakers who used pot and killed their children. And we have photographs, and we got that from Parents Opposed to Pot. So those are the types of things. You can throw a million studies at somebody, and it's not as convincing as them reading a story and seeing a photograph of what actually happened to a real life person. And having those people come and testify before the legislature. We had Corrine come and testify before the North Carolina legislature. And I know it's difficult for those people. They have to relive the trauma every time they talk about it. But people listen and they pay attention and they see, gee, this is real. This is really something that I need to expend time and energy to reverse.
Absolutely. Thank you. Don Danielson, do you have your hand raised?
Yes, I do. I'm sorry, I can't get my camera to come on. Anyway, yeah, name's Don Danielson. I'm in Washington State. my wife and I, we lost our adult child. He was 27 back in 2019 to CHS. It's even on the death certificate. And honestly, up until this very conversation, I hadn't considered any kind of lawsuit for a number of reasons. One, he was married. We thought, I'm completely ignorant of the law. We thought it was only next of kin that could do that. But he was diagnosed with CHS. I'd have to go back and look, but I'd say a year or two ahead of his death, and from a doctor in the ER room. He went to the ER a couple times, and in Washington State, pot's been legal around here for a long time. He was buying it from a local pot shop. And I guess I'm just looking for general direction more than anything.
Are you looking for a
Well,
lawsuit? Don?
cannabis hyperemesis syndrome can be fatal. You know, the marijuana industry always talks about how pot never killed anybody. Well, it does with cannabis hyperemesis syndrome. It can cause you to die.
Yes.
And the thing to do is we can help you with that. We would need to get a lawyer in the state of Washington. And sometimes it's difficult to do it. Other times it's pretty easy. So we'd be willing to work with you. The issue there would be the statute of limitations and so forth. And again, I have to tell you that everything that I would help you with is for informational purposes. It can't be considered legal
Sure.
advice.
I understand.
But this is the kind of thing that we would work you and try to help you. And you know, you have my contact information on the PowerPoint that you'll receive, and we'd be happy to work with you.
Okay, thank you very much.
And we give you our deepest condolences, Don, to you and your wife. And I appreciate you allowing me to share your son's story in my presentations.
Absolutely.
Thank you. I think Doug, are you on the line? I think you had a question from Florida. Are you there?
Yes, I do. Yes, I do. This is largely for Dave, but it's very related to Dr. Miller's questions. Dave, early on in the discussion, you talked about, when you were talking about the potential, causes that we could use in lawsuits. You did mention third-party harm, but then later you mentioned it in terms of, as an example, somebody who was killed in an auto accident or something by a person who was under the influence. But in these typical cases of families with adult children, like Dr. Miller brought up, is it possible to bring suits there for malpractice or something else as a third-party family member? I have experienced all the things Dr. Miller talked about, and particularly the inability to revoke a card no matter what. That just, in Florida, that can't happen. Apparently it can't in Maryland either. So that's really the question, is the third party thing. But before you answer that, I want to make one quick comment on George talking about evidence and said, keep the diagnoses. What I have found, and I've been told this by several different treatment facilities here in Florida, they don't give that diagnosis of cannabis-induced psychosis because most of the insurance companies will not cover it, and therefore they will put schizophrenia or bipolar, and they may put cannabis use disorder or cannabis dependence, but they will primarily diagnose it as either schizophrenia or bipolar, just so the insurance will treat it. And then you don't have legal grounds because the diagnosis doesn't say CIP, even though it really is CIP. Because like I overheard Linda's discussion and how, her son's psychosis just completely goes away with abstinence. And that is the way that you determine that it's cannabis-induced psychosis and not bipolar and not schizophrenia. So, okay, Dave, third party.
Right. Well, again, that is going to be a factor of state law and what state law would permit. We one of the reasons that we want to do lawsuits is to bring attention to these problems. There may be state laws where you have the right to commit the party. There might be state laws. Dr. Miller brought up about, losing the consortium of your family. It's just, I don't know that there's anything that I can say about that, except that, you got to look at your state law and find out. We don't know everything about all the state laws. There's a lot that we still have to learn about it. And we have to just keep working away until we can, we're all a bunch of little tugboats trying to turn around an aircraft carrier that's going at full speed. And it's going to take a lot of us to do this a little bit at a time. But we get experts like Dr. Miller and some of the other experts we get those opinions out there. Other lawyers get a hold of it and they'll start to use them.
Thank you, Dave. Thank you, Doug, for your question. Joanna, first of all, before we go to Joanna, I just want to make sure, Aaron, George, and Dave, are you okay for one more question? I know we've been on for a long time. I just want to be respectful of your time.
Yes, and it would be useful for me anyway to have a list of these questions or some way that I can access them later on, because I think Dave and I at least are going to want to follow up on some of them.
Yeah, that would be great. And we're happy to navigate that through the Every Brain Matters community too, and email the responses to everybody too. So just let us know if we can help. So I can for sure, the chat will be saved and it's recorded so we can get you those questions. Okay, go ahead. Thank you for staying. Joanna Lester, please. Oh, you're muted, Joanna.
It's Johanna.
Okay.
I have several questions. First of all, I lost a son. I'm not sure that it was exactly to marijuana. At the time he had an accident, but that was 23 years ago. What has happened in Minnesota is the state has passed a law which not only legalizes, but sets the state up as the only producer of marijuana in the state, using state funds to set up a marijuana board. And it seems to me that we should be able to sue the state.
If I can just deal with that question right there, we're about to do that in New York. We're going to file a federal lawsuit. The state is going to be funding marijuana trafficking stores.
Yes,
and we're going into federal court saying that is federal, that is illegal under federal law. It's funding drug trafficking. And we also are going to be doing that in Minnesota. So we have started the process. We have an attorney in Minnesota to do that. One of the people on this call is David Benson Stabler, who is heading up our effort there. You can send him a chat, and I'm sure he'd love to hear from you.
Yeah, I've talked
and we
to
have
him
some
already.
initial funding. We have some initial funding to get that going also.
Yeah, so the state is promoting a product that causes harm. That's another issue. It's something that we know causes harm, if nothing more than just smoking it. It's worse than cigarettes.
Well,
So
they don't perceive it as causing harm, and that's the problem.
But
They're
we
not,
know,
they're ignorant.
we know that it does. I mean, there is evidence.
Yeah, but they don't. They don't.
They don't, but they can
And
be
they've been
seen for
convinced that
not
what they're doing
knowing.
is right. Yeah.
But the state should know what, I mean, the health department has been behind a whole lot of this. So, it's out there. If they aren't accessing it, then they are.
Yeah. We have some disagreements with some of the health departments, and that's a whole new different discussion. We haven't we had some full cooperation from some of the health departments. So we will address that though. Thank you for bringing up that issue. And we agree with you. They should know. And believe me, we have written letters after letters, phone calls, meetings. A lot of us have been advocating to educate the states about how harmful these products are. So thank you for your question. I do see a good question in the chat. Do you believe warning labels will grant immunity to the marijuana industry from paying actual damages and punitive damages?
It will. We had to weigh that factor. We came out with a model cannabis consumer right to know law, and we thought through that. And on balance, our job is to try to prevent marijuana use. And warning labels at least have been demonstrated in the tobacco industry to deter people from using it. So we decided on balance that our job was to issue the warnings, because to not issue the warnings is the same thing as admitting that there's no harm. If somebody says, well, nobody ever warned us about this to do this, that statute has been sent to every state marijuana agency. I communicate with them on a regular basis. They get all kinds of nasty stuff from me. Whenever we have a lawsuit, I send them a copy of it, and it does have some effect. I know when we sued New Jersey, when they finally passed the regulation, we couldn't stop them, but they did put in a whole section in there about how this violated federal law. So I thought it was very interesting, which we're going to use in lawsuits against them. And they cleaned up their act. They put in a very good pregnancy warning. So warnings do help. And if we don't warn people about it, then we're a co-conspirator in keeping the truth from the public. If you want a copy of our marijuana warning thing, I'd be happy to send it to you. We're looking for legislators to get it admitted. And my contact information is on my the PowerPoint, so I'd be happy to send it to you. Anything I send to you, you can use as you see fit. There's not going to be any copyright issue with anything that I sent you, that I wrote.
Thank you, Dave. And good question, Harris. Thank you for that question. Okay, I think that's all the questions I see. We've almost been on for 2 hours, so I think that's good enough for today. Actually, it's more than good enough for today. This is very important what happened here today. This is historic, and we will continue this conversation. Maybe ask the lawyer. We'll get it even more organized than we are now, and get the right information to the right people, and allow people to find us too. So thank you, Dave. Thank you, George. Thank you, Aaron, for being here today. We hope you all enjoy, and we thank you all, the audience, for being here today and stepping up. We need all of you. We need your support. So till next time, we'll see you later.
Thank you very much.
Thanks.
All right.
Thanks so much. Thanks, Aubrey and everybody.
Take
Bye-bye.
care. Bye-bye.
I'd like to thank Aaron and George. They've really been wonderful, and they're going to make a big impact in this area. So it's really terrific. Really
Thank you
wonderful.
for leading the charge.
Thank
Dave.
you, Aubrey.
Yeah.
Thanks, everyone.
We're so
Really
grateful
appreciate it. Take care.
for people stepping up. Take care. Bye-bye.